exactly why.
That evaporates.
Both of them have liquor in there. On the record.
But they were worried you weren't coming and had a big Valentine's Day scheduled or something, Cal. We're on section 5, which deals with practice issues related to injunctions. We looked at Rule 52 the other night. Rule 58 is also on our agenda today. And we mentioned it briefly the other day, and it's really a relatively brief rule as well. All it simply it requires is that a judgment, the order of the court, be set out separately and then be entered separately. And why it becomes important, specifically when we start to think about injunctions and compliance with the court's order, whether it's a order to do or not do certain things, is that that then carries with it the potential sanction of contempt. And so when we look at someone being in contempt, we have to have a clear, unequivocal order as to what that person was supposed to do. And so Rule 58 tries to make sure that when that judgment or order is issued, it's issued in a separate document, and therefore one can look at it and understand what's required of it. And it also helps us to know what we're looking at for our time periods for appeal. I was pulling the cases for bar exam takers at the end of the month. And again, there's a couple cases within the last year that reinforce the basic notion that you guys should be aware of, obviously, as well, is that if you've got 30 days to appeal and you appeal on the 31st day, you're up. Those types of time frames, especially post-judgment, are strictly enforced, and pre-judgment are as well. And I hope you recognize the importance of, if you're going to go into this profession, that we have deadlines and the court expects them to be met. And if you have an inability to meet deadlines, you really should be in a different profession. But especially where we see this is post-judgment, post the entry of judgment under Rule 58, when there are time periods to do something, whether it's moving for a new trial under Rule 59, or it's to vacate the judgment, or simply to establish your appeal. That's not something you can sort of put on the back burner and say, well, I'll get to it when I get to it. If you don't comply with the timelines, you're going to be out, as you should. And again, there were a couple cases within the last year. There's always a reason why they weren't complied with, but they weren't. And the court doesn't go out of its way to help fix the errors that you've made. We have two more cases to look at, the Republic of the Philippines case and the original Great American Chocolate Chip Cookie Company, as we look at the practice, the process of issuing injunctions and how that will work with respect to the case when you are either working for yourself or working with a firm and they send you over and say, okay, go see if you can get this injunction, because they expect you're not going to be that successful anyway. But you're probably likely going to get your ears boxed in a little bit, because you're asking the court to do something extraordinary, and hopefully your papers show that type of a level of diligence that they should, and thoroughness. Because the fact is, if you're going in with a temporary restraining order such that you're asking to do something without notice, the standard is a little more exacting on how well you've done your job. And even if you're going in having provided the defendant some form of notice, then your papers should be in order if you're asking the court for what this case refers to as an extraordinary remedy. And it is an extraordinary remedy to order someone to do something. Here, the Republic of the Philippines sought appointment of a receiver to manage and control buildings. And there were various requests for injunctive relief and things like that. So I guess I'm first wondering what this receiver is, because we see it in a few cases. It is a remedy available. It is an extraordinary remedy. So what is a receiver? What does the receiver do when the court
control of a corporation?
So it takes control over that entity.
Has the power of it.
say what?
Has full power.
Has full power to control that entity, and to do whatever it takes to run that entity, to manage the corporation, and in fact, in some cases, it will end up liquidating the corporation if that's necessary. So the appointment of a receiver really, in essence, ousts those that are in control of the corporation, and the court appoints its own person to operate them. We've seen them in a few high public profile cases around here. At one point, there was a receiver appointed over the apartments belonging to the Boston Housing Authority and the like, because of their failure to comply with the court orders and the like. But it truly is an extraordinary act by the court here. And here, what they were looking for is by way of the injunction and the appointment of the receiver to manage 4 commercial properties in New York. Why are we looking for such an extraordinary remedy? I mean, that seems significant, especially pre-judgment here. Why? What's the problem? Ben?
It's because they almost went in default. They were trying to decide who owns them. So before they got lost, the bank, they wanted to figure that out. Try to
Right?
keep them maintained.
Go ahead. Number of tenants, mortgages that need to be paid. The fact is if they're not managed during this, the likelihood is there's going to be nothing left potentially at the end. There's a bunch of other things going on. If you look at this case, they're worried about the properties being looted by the people who were supposed to be in control of it. They want declaratory relief, which we've talked about before. And then there's Republic moves to consolidate its action and to intervene as of right in this action, but did not request, it said, an evidentiary hearing. And we'll come back to that because that's partly why we're here. What's this intervention as of right? What is that all about? So they're not a party to the case, but seek to be involved as a party. How come?
Is it because Imelda Marcos and Ferdinand Marcos, because they represented the state at one time, and now the Republic is representing, essentially? If that makes any sense.
Representing who?
Republic of Philippines.
Wants to intervene in this other action themselves.
Right, because the Marcoses used state money, basically embezzled state money for years.
Right.
So they feel like they're the rightful owners because they feel that money went towards purchasing these properties.
Well, what gives anyone the right to try to seek intervention in someone else's suit? When you looked it up in your little rule book? Oh, that's right. You're not first-year students anymore. You don't have to look stuff up. It just comes to you now. What?
And if we don't know, we make it up.
Yes, that's true as well. But you know, there were a fair amount, a number among you who did that first year as well. Is it?
Just a different kind of makeup.
Invent it when you don't know what it is, and I'm not supposed to know.
We try to get some.
Really, that always astounds me. You read it and say, well, shit, that's just completely made up. Go ahead.
Is it because their rights could be affected?
Is that a statement or a question?
Well, I'm thinking it's more like standing. Like if their rights eventually will be affected, then they have rights.
So if they can show that their rights will be affected,
Correct. Their
That's-
interest, I guess.
that's the D answer. You don't look at me like that, but that's about a third of the standard, just so you know. Yes, you've got 1/3, so you're at
So am I
32.
on the right track though?
Yes, you are absolutely on the right track.
A stakeholder in the case, like they.
But what does that mean? They're a stakeholder in the case.
That their interest relates to the subject matter of the action.
So they have an interest in the
So
case.
they have interest, and if they don't participate in the action, their interest would be impaired, or they would be at a loss.
And what did you say?
They have an interest.
Okay, so they have an interest in the case. A lower adds to that,
Right.
and that if they're not involved in the case,
They lose the end.
their interest may, as a practical matter, be impaired or impeded.
are not adequately represented.
Well, you didn't give me that part yet. There's 3 parts, that's why I said,
There's a statute part too.
I was being generous with her indeed, by the way. So there's 3. There's 3 parts, right? So what are the 3?
For as of right, it's
Well, let me just explain again to you guys the difference between as of right and permissive. As of right means the court doesn't have the ability to keep me out. And so keeping me out means it's error, and that gives me another grounds for appeal. Permissive intervention is the court decides they want me, but that's permissive, and it's discretionary, and the court can say in or out, it's at their whim. So as of right, I can intervene under what circumstances?
you have an interest relating to the property transaction.
And if an interest in the case of the property of the transaction, that's the subject matter of the dispute, right?
Yes, I'm sorry.
No, that's okay. B.
When a statute confers or unconditional.
Yeah, that's going to be very rare that the statute confers an unconditional right. If it confers an unconditional right, it's almost always on the government, not one of us.
And you also have, if you're not adequately represented. by
Okay, but
existing
and
parties.
that's a big part of this that we, so we have an interest in the case. That interest is not presently represented by any of the parties in the case. And
Well, you get it, well, if there's a similar question of law and fact, is that in that one?
well, that's going to be, I think that's going to be the first part where there's an interest to the case and of the subject matter of the dispute. The last part is that as a practical matter, your absence will impair or impede your ability to protect that interest, as Lois said at the outset. So it's really 3 pieces. I have an interest in the case. That interest isn't presently represented by any of the parties there. And as a practical matter, the disposition of this case may affect my rights, my ability to protect my rights. And so while it's rare, there will be cases like along these lines where, geez, if I wait till this case finishes out, there may be nothing for me. And my rights are going to be affected.
So you said the federal statute situation would be rare. So would you say that situation where those 3 conditions are met is the most common way that someone may intervene?
As of right, yes.
Can I ask you
That's
something?
24A2.
Yeah, because the federal statute it's going to confer the ability on various agencies and the government itself. But for private parties, it just does. It's not. You're not going to see it that often at all. Go ahead.
This is off topic, but I'm thinking of abortion rights, and how is it that a parent can't say what a child can or cannot do, and yet if that child has that baby and that teenager lives in your home, then your rights are impaired already. Can they bring this up and say, wait a minute?
What do you think?
I would think so.
So we've got a statute. I mean, just quickly, because we've got a statute that says a 16-year-old can, with court's permission, get an abortion even if her parents don't. So she petitions the court. Parent seeks to intervene. What do you think? Let's see. I have an interest in the case.
I do.
Yeah.
I do. By law, I'm obligated to take care of one of them. As a practical matter, I'm going to end up taking care of 2 of them, right? No, hope it's only 2. No one presently represents my interest in the case. It's really there is. I'm not even sure it's adversarial per se, right? It's the child petitioning the court. There is no one else that would potentially be the person that advances the other voice. And as a practical matter, the disposition of this case may impair or impede my ability to protect that interest. Let me change it up on you and make it more interesting. What if it's the 17-year-old boyfriend? Doesn't he fit that standard even better?
It sounds like he's like an indispensable party to the case.
I wonder what...
I mean, he doesn't have control.
It certainly was in the beginning.
I think you'd have more standing.
If the girl's
there.
father, he might be suspicious.
What do you think about that? Going to give this right of intervention to the father of the child?
If he's the father.
So you will. So you will allow him to potentially control
Wouldn't you know?
whether that woman has to carry that child to term.
No.
So, but the grandparents can't.
I didn't say they couldn't.
Just to plumb the,
I didn't say
right?
they
Because at least one of them is another woman.
No?
How old is the girl?
16.
16?
Well,
Girl 16, boyfriend 17. Grandparents are likely going to be footing the bill for a while here.
well, the problem is you've got other laws or other areas of right, like Roe v. Wade rulings and other constitutional issues that come into it as well. So you'd have to intervene, you'd have to overcome those as well, I would think. You'd have to say, I have that right to be involved, right?
Yeah.
Because the other side's going to argue, their argument's going to be, no, this is my body, I have a right, you have no right here, get out of here, right?
But do you have a right if financially you can't even support yourself?
That's a whole nother area. That's
And the
not-
medical insurance with which this child will be born will
It's
be
on
mine.
my insurance.
Yeah.
Not
And
that
then
my daughter's pregnant anybody.
Well, that's
No, no, we
Whatever
understand.
happens, I need to
No,
know.
it's an
That's the argument for the state, maybe. The state might say, hey, listen, I might have to raise this child because you're on welfare or something, and I'm giving you insurance.
So now the state gets to come in
And
and
the state
get
says, I have to
make
pay
the
the
vote
insurance bill
too?
for the pregnancy, and then the state might try to get in.
Listen, this is an interesting topic. It's a question for you to think about. But this, when we do talk about intervention, a lot of times, by the way, this is a straight business transaction. You do see, especially in some of these cases, where people seek to intervene because they want to have their voices heard. And the advantage to being an intervener, as opposed to simply an amicus, is an intervener gets to appeal. So if grandparent or boyfriend don't like the result, the court approves the abortion or doesn't approve the abortion, and they want to be heard. They want to challenge the order. As an intervener, I have the right to appeal. As something less than an intervener, you do not. Right? If you're not a party to the case, you're stranger to the case, you don't really have much of a right to object to what took place in the case. The other part about an intervener is you have the right to offer evidence and challenge evidence and examine witnesses and all the rest. So intervener gives you significant status and gives you full rights as a party. And that's why people seek it. And I don't know what the answer to Sunshine's question is. I just know when we've looked at this before, because we actually did a show one time on this issue about father's rights under such circumstances, and the law is pretty clear that the father, married or not, doesn't have much say so over the disposition here. And so, to me, if the father doesn't, I think the grandparents are even more removed than that, even though I understand completely what you're saying about, yeah, in theory, I'm really removed. In practice, the next 10 years, I'm responsible now, right? And we know that as a practical matter, that is the situation in a lot of cases. So it's an interesting question. Sunshine will do the research and report back at our next meeting. So the receiver, as it talks about, is this extraordinary remedy. They didn't request an evidentiary hearing, and that's why I wanted you to look at it, at least from this standpoint, is this notion about whether I get an evidentiary hearing. The first big thing to take from this case is if you don't ask, you don't get in this business. Okay? So if you don't stand on your rights in the district court, if you don't stand on your rights in the trial court and demand what you believe you're entitled to, then don't complain later on that you didn't get something. And that's true straight across the board. It's true when we do trials. It's true when we look at these types of things. When after you've had some time to think, you say, oh, I wish I asked for an evidentiary hearing. I always make far better arguments a month after the argument was actually made, when I've had a lot of time to revisit the day and rethink about how I should have pitched this or that. But that's just not the way this business works. It's not the way evidence works, as you know, when we talked about that in class. If you have a problem, you've got to voice it at the time. And here what we've got is what the court is saying. If you look at the page 36, they're asking for an extraordinary remedy. This will oust the management of the existing entity. And it should be employed, as it says here, with the utmost caution and granted only in cases of clear necessity to protect plaintiff's interest in the property. And so then what they decided to do is, what if it's just a special property what do they call it? Special property advisor, I think is the language they use. And you know what? The court does that a lot of times too, is let's play with the language and see if we can make everyone a little bit happier here. And so I think that's another interesting piece to this case. nearly finally. It talks in page 36, the paragraph that's labeled 2. The district court is expected to use the flexibility traditionally associated with equitable remedies. And we've talked about how discretionary equitable remedies generally are. But I think that's an important piece to think about, especially as you start to think about pitching arguments to the court and the like. Equity, when the court sits in equity, it has broad powers to fashion appropriate relief to the circumstances of the case. And it should be flexible, and it shouldn't be simply a blanket order of any sort. The court has to use its broad discretion to provide the right relief, the relief that will be tailored to the circumstances. And so I think you need to think about that in the context of, well, so doesn't that give the court pretty wide latitude as to how they ultimately fashion relief in an equitable situation? The answer is absolutely. Finally, they do go into this whole problem with respect to the evidentiary hearing. And the court, as you see in page 37, says that there is no request for it. If they don't request it, you don't have to do it. And this is the Second Circuit now here, which is New York. It said, we recently held that on a motion for PI, where essential facts are in dispute, there must be a hearing, and appropriate findings of fact must be made. They cite this Fengler case. But then it goes on in that paragraph a little later to say, it is not a rigid requirement that oral testimony be taken on a motion for PI. So they're saying there has to be a hearing, but that still, the process of that hearing can again rest with some discretion with the court to fashion the appropriate hearing as they see it. And then they get into a little bit this problem with what happened with the findings of fact here. And what they say is that Judge LaValle's orders failed to satisfy the findings of fact and conclusions of law required under Rule 62. And they dismiss that argument because what they say is that the district court must set forth the findings of fact and conclusions which support its order and provide its reasons for issuing an injunction. Simply state why you're doing what you're doing and what specifically you're doing, because again, we may have to be looking at contempt if the order isn't followed. And what happens here is that they were sufficiently satisfied that there were clear findings in a clear order as to what the court at the end of the day was looking for. And so you don't get a hearing even in those jurisdictions where it may be favored, as it is in the Second Circuit, if you don't ask. And B, as long as the findings of fact and conclusions of law are made in some fashion, then that's frankly enough in order to move forward. Let's look at the original Great American Chocolate Chip Cookie Company, because I like this case. But I've had some questions on it. I guess this is another one of our franchisee situations that goes bad. They were at a shopping mall in Aurora. The company sues them. They don't want these guys using their intellectual property anymore, and they ask for a preliminary injunction. The Siegels then counterclaim, saying that their franchise was terminated in violation of the agreement itself, as well as various state law protections for franchisees. And again, we know from the last time we looked at this that there are protections under both federal and state law, and specific requirements for disclosures and the like under both federal and state law for the franchise relationship. The court, at least at first, let me ask you this though, I'm sorry. It talks about a magistrate judge. says the magistrate judge recommended that the district judge grant the Siegel's motion for a PI, and he obliged. What's that all about? The magistrate judge makes recommendations to the judge? What's a magistrate in federal court? Do you know how that works?
Is that a judge's helper?
Judge's helper. That's the way it reads, doesn't it? And in fact, that's basically what they do, although they do hear cases, and they are judges. And every federal judge is assigned a magistrate judge that works with them. You can actually have your case, if you want, heard before the magistrate judge, which is usually faster. But then it's still, at the end of the day, has to be, the judgment and orders have to be approved and reviewed by the district court judge that's assigned the case. And so to me, it seems like it slows the process down. A lot of times, it may make sense to have discovery disputes and things like that handled by the magistrate judge. But at the end of the day, the judge is still, as it did here with the preliminary injunction, has to sign off on it. So it's a process you need to be aware of and think about, because to me, I've always felt that it's going to slow things down, and it does a little bit. But sometimes, depending on, you won't get to see Judge X for 2 months. I can get you before the magistrate 2 weeks.
But they consider like the magistrate judge's recommendation, like the district court usually does.
Yeah, it's not just, calling it is a recommendation, but calling it to some extent minimizes it, because it's a full hearing. It's, if we have discovery disputes that warrants taking of evidence and things like that, the witnesses will be sworn in, there'll be a stenographer, there'll be testimony. The problem is it always seems to me like, well, then I could end up doing things twice. And the answer is, yeah, that's true. And I don't mind the magistrate judge, frankly, attempting to do the alternative dispute resolution, get another voice in here with enough experience and the like. But if you think about it here, so I got to try my PI and be successful before the magistrate. Then the magistrate's got to make it, so I got to win there. Then the magistrate's got to write a sufficiently convincing decision that the judge themselves agrees with the magistrate. It's a slower process, obviously, and maybe leaves more room for, I'm not going to get what I want. What do you guys?
I was going to just make a comment, and they're not as educated as a judge, right? Usually.
Not necessarily. That's not necessarily true. They're all attorneys. They're all practicing lawyers.
How about the ones in district court?
Oh, okay. I'm simply referring here now to federal court magistrate process,
right,
where every judge has a magistrate judge who works directly with them. You're right. In state court, we call a lot of people magistrates.
Right.
That some of those magistrates may not even be practicing lawyers. And that's a different process, so that's fair. In federal court, sometimes, frankly, the magistrate might be more comfortable with the skill of the magistrate and the experience than the actual judge that ultimately controls your case. I've had both situations where I haven't been comfortable with the magistrate, or I've been more comfortable with the magistrate than the judge. It's just a question, because they're people too, so it's a question of who they are. But from the standpoint of education, it's basically the same. The experience may be less, slightly less, at least as a judicial official, because it's like everything else. Do you want to be the second person or you want to be the top person? Usually a magistrate judge aspires to be the judge. But especially in this district, and that's where I've appeared before magistrates at various times, I'm very comfortable with the qualifications. I'm not comfortable with sort of this intermediate level of work that at the end of the day, judge still has to sign off on whatever is done, and the judge is going to make the call. So it seems like an unnecessary layer. And they'll ask you early on, do you want to refer the case to the magistrate judge? As a matter of routine, I say no. I'd rather, okay, so I'm going to wait a little longer.
It just seems repetitive.
It is repetitive. It is, I think. It is. If you have a complicated discovery dispute where it might take 3 or 4 days of hearings to sort it out, say it's a privilege issue or something like that, and there's going to be testimony, and there's going to be a lot of things examined in camera, maybe that makes sense. But to think of trying the case twice, or to, slowing it all down to have everything referred to the magistrate, that just doesn't work for me.
I was wondering, can you split it off through the discovery stuff?
Yeah, exactly, and exactly. You can decide some things can go, but some things don't. But sometimes you'll get a question. Early on they'll ask you, do you want to just simply refer the case to the magistrate judge for resolution? Well, not really. I mean, I don't. I prefer, because at the end of the day, it still has to be resolved in all likelihood. I do almost exclusively plaintiff's work. I'm looking for a jury trial in front of the judge with the jury impaneled, and what that means then is that's some more involved and lengthier process, but that's what I'm looking for. So I don't want to try my case before a magistrate without potentially the benefit of a jury anyway. I want to reach the ultimate fact finder in the process is my goal. And if you look at what happened here, this is a pretty good illustration. So there was some process where the magistrate judge took information in, whether by way of evidentiary or otherwise. That magistrate then judge, when it said recommended, wrote a decision, in essence, making findings and the like to the judge. Then the judge has to review it. And here's the problem, right? That judge is reviewing it now without the benefit of having seen the witnesses. So the chance that the judge will reject the magistrate's finding simply because the magistrate didn't write it as powerfully as they might have received the evidence is worrisome to me. Look at the witnesses. Review the evidence in person, not just a paper decision. You don't get the same feel for it. But what happened here is the court adopted and incorporated Bucklow's report and recommendation. And so here's the problem. There was no separate injunction order, but merely an incorporation by reference of the draft of the injunction contained in the motion. Okay, that's going to fall short of this Rule 65 that we talked about, where if there's going to be an order, it must be clear and unequivocal what that order is. It should be set on a separate piece of paper, and so that then if there's going to be contempt or if there are other issues concerning compliance with that order, we know what it said, and we're not simply relying on what someone else says it's supposed to say. Let's talk a little bit about the merits of the case here. But it does talk to you here about the it could potentially be punished by contempt. After the district court judge entered his order adopting the magistrate judge recommendation, the cookie company successfully moved for an order requiring the corporate defendant to post a $10,000 injunction bond. And by making that motion, the company acknowledged, the court says, that it knew it was enjoined. And it would be stopped to deny this should the Siegels, having posted the bond, later move to enforce the injunction. What's this bond about? Because this is the first time we've seen an injunction bond. What's the bond for? Go ahead.
It's insurance in case you lose, I guess. So if your injunction was granted improperly, or if it fails, it protects the other party in case. So kind of like an insurance policy.
So the party who gets the injunction, in this case they had to post $10,000, and that $10,000 is for the cost to the party against whom the injunction is granted, in the event that they incur costs and it's later determined that the injunction shouldn't have been granted.
Yeah.
Right?
I'll go with that.
That's what it is, right? So this is another hurdle here as we start to see it, because that's a lot of money to be able to have to post, and potentially you risk losing it if the court later determines that the injunction wasn't properly granted.
How big can those bonds get? I mean,
10,000
is a lot, but I imagine this injunction that could cost a company millions.
Oh, sure.
I mean,
Sure. Yeah. The example one of the examples I always tell you guys at this time is this. This was a long time ago now. I don't even know how long ago it would have been. I could figure it out. But when Danny Ainge was playing for the Toronto Blue Jays, and the Celtics wanted to allow him to come play for them because he wasn't much, well, he was an okay baseball player, but he was a better basketball player. He decided to leave. The Blue Jays sued the Celtics and Ainge, saying they wanted an injunction preventing him from doing it because they had a contract with him. And what happened is that they were able to obtain the injunction, preventing him from going to the Celtics. But the Celtics were successful in getting such a sufficiently high bond, in case it's later determined that Ainge shouldn't have been enjoying, because Ainge is losing all this money from playing basketball, that the case settled before the posting of the bond, because it didn't make financial sense for the Blue Jays to sort of hold him hostage when the Celtics were willing to buy him out, and they didn't want to post a bond that could have been millions of dollars, because that's what he truly could lose during the duration of that contract that the Celtics wanted him to play for. And that's relatively modest by standards today. You could have businesses in some of these disputes where realistically, during the duration of the case, you could be talking about potential harm of millions of dollars. And the way the rule reads is that the bond should be an amount sufficient to satisfy the losses if the injunction is later determined to be improvidently granted. In a business context, that could be.
So that becomes very tactical then.
Absolutely. It is another layer of our argument then about why, first we oppose it on the merits, but now start to think about it. One of those opposition on the merits is harms, right? The balance of harms. We've talked about that. Well, if I can make the argument that I'm going to suffer a lot of harm and now convert that to economic dollars, right? Make an economic argument of it. Not only do I get to use that for the harm argument, but I also then can use it for, and if you're going to grant it, our economic losses for this will be $3 million, and that's the amount I need the bond for. A lot of businesses can be hard-pressed to get a bond worth $3 million. And so the case may fold simply because they can't get the injunction, because they can't produce the bond that the court requires. The bond becomes a significant second level of argument if it looks like we're likely to lose the injunction request. And it's actually, you start to set it up as you start to think about that balance of harms argument, because that's where this naturally goes. For instance, even take the employment situation we were talking about the other day. That poor guy, there should have been a strong argument that Campbell's, since they don't have a non-compete, they are going to freeze him out in essence for 9 months of the year. Suppose he's making, just make the numbers easy, he's making $200,000, 9 months is 3/4. They should be posting a bond at the minimum for $150,000 for his losses if the injunction is later determined to be improvidently granted. Now, for Campbell's, that still isn't that much money. But you know what I would argue? I would tie it to 93A. You're going to have a little trouble, but I would say his damages are going to be $150,000, and under 93A, those damages will have to be doubled or trebled. And under 93A, he would also be entitled to his attorney's fees. So we're looking at a bond north of $500,000 if Campbell's successfully is successful in obtaining the injunction, because that's the damages that he will likely suffer, because with absent the non-compete, there's no basis to prohibit him from working and making a living. You might come away with a bond for $250,000 under the with a good argument. You might come away with a bond for $250,000 under that circumstance. $250,000, that might make Campbell's think. Probably not, right? Still pocket change to a company like that. It's going to make a lot of companies think, though. Okay. So the bond is this other part of it here. The bond is not a big deal, but isn't this case? Isn't this case much ado about nothing? So what were they doing wrong? It's cookies and brownies and. Oh no, there's nothing that bad.
No, this is.
Geez, I got a problem with a few kids who work the counter. We can straighten it out, can't we? No. What are you saying no for?
This went on and on and on and on.
What do you mean on and on and on? What went on and on and on?
Just they had a list of all the things they were unhappy with, and
Well, but-
that really didn't meet the contract terms, really.
But like, what are we talking about? I mean, are there serious violations, or sort of
Well, there was no health violation, so it's serious, not health, right? So runny cookies, there might not be on.
Yeah, runny cookies, I mean,
Yeah, the running cookies and stuff, that's kind of the low end of the spectrum, but they're not paying their bills on time, they're not running a clean operation, they're,
shorting the count.
Yeah, they-
shorting the count, that was the big one, selling unauthorized product under the cookie company roof.
They have
They did
ignorant
that after
employees.
they had to, though.
Ignorant employees. That's all enough, I mean, you're good with this? Gum under the counter, didn't they say?
Yep.
I would say
I've turned over some of these tables, by the way. You don't want to put your hand under there. If you represent the cookie company, this wouldn't be a problem forcing these people out because you're taking everything they have. Right? That's what it says. The Siegels used borrowed money to invest $125,000 to $130,000 in fixtures, other improvements. They even took the grandfather's retirement. Because this is going to have devastating consequences for the Siegels, isn't it?
Well, not that they didn't see coming. They had plenty
Not,
of points.
so they saw it coming and
They were told. It's not like they weren't told, you know? It's like you got to run a good, at least the averagely good business. Or
They're underreporting their gross sales by $40,000.
Yeah, that's not a drop in the bucket for two worlds.
so they ran a lousy shop. They in essence stole, and now this is the fate that they've placed themselves in.
with repeated warnings. If there wasn't repeated
With repeated warnings.
You know, it's not like,
So you wouldn't have a problem doing this?
well, I mean, it's not something you want to do every day, but
No, I don't disagree with that. That's right. This is not a problem of my making, but I work for them, and now out you got to go. And if Miss Siegel's father loses his house and his retirement, it's just the way it is.
well, assuming that they can't sell the franchise and get some equity out of it, right?
Well, but I thought they were going to lose the franchise. They had offered to take it back, and they wouldn't give it back, I thought, at some point.
Yeah.
And now it says, yeah, the cookie company has offered to let them assign the franchise for a consideration that presumably would enable the Siegels to recover most, perhaps all of their investment or more for that matter.
Right.
But they claim not to make a sufficient other income to make the payments required to service the loan until the assignment is complete. They fear in the interim the loan will be called and they will lose their home and the other assets they pledged, 2 houses and a retirement fund of Mr. Siegel's father as collateral for it. I mean, geez, they're talking about losing everything, and you're the agent of destruction here. For running cookies, gum under the counter, and some 16-year-old kids who don't want to wear that hair.
What's the
anymore.
alternative? We'll give you one more chance? But, you know,
Well, is that right?
but they've done that over and over and over and over and over. They're not going to do anything about it, so, you know, how many chances do you want to give them? You know?
And in fairness to the company, you're injuring our brand.
Yep.
And then some, right?
And stealing, right? I mean, shorting the counter stealing, using someone else's product is stealing from us.
And even if they were to have to pay damages, they wouldn't have a way to pay it. They can't afford anything.
Right.
So the company wouldn't be able to even get damages from them.
Well, theoretically, they could have an offshore account with all the money they've been stealing. Well, how do we
Okay,
know?
so like theoretically.
Well, I don't know about
Probably not,
all the
but-
money they've been stealing. It sounds like
Probably not.
they're really not very good at business, so I don't know how much they could have been stealing.
That's conceivable.
That
might be the best argument, then. It's like, you know, you were supposed to train us, you shouldn't have get us into this thing, you shouldn't have overpromised and underdelivered. That's all they got, really. If they're poor business people, they shouldn't be in the position.
Well, it sounds like they're in way over their heads at this point.
Yeah, but I think it's something.
And that's their own making.
Or they're poor business people, one or the other.
Does it matter, and I agree, does it matter to you that the Siegels say, well, other franchises have been treated more leniently here?
You gotta prove it, burden's on you.
That's not good enough.
That's not good enough.
What does that mean?
Yeah, that was the,
In
that was
what
the speeding
regard?
ticket defense they were throwing up.
Well, suppose other people have bounced checks, you didn't terminate their franchise.
Habitually, over the, I mean, it doesn't, there's a pattern of behavior here that
And,
continues.
yeah, and I think that they were lax. I mean, 7 years, it's not like they were given leeway, they knew. If everybody else is bouncing checks, did they have a 7-year leeway too?
It doesn't seem to you a pretty harsh result? Though the contract was fairly clear, and this isn't a check, 7. This isn't a problem with food, it's multiple problems. It isn't a problem with cleanliness, there are multiple problems. Companies offered to try and work this out. They don't appear to be capable of doing it. There is the concern about to what extent you're injuring other franchisees if you do this. And you know, the theft issue is not insignificant either. So it was the Siegels who sought the injunction, right? And at some point, they were able to get it. I think, well, why do you think they were able to get it then?
Simple judge irreparable harm.
What'd you say?
Immediate irreparable harm.
Is that right? And then the balance of harms, that if you had to, what? What are you saying?
I heard Gary's comment.
Sorry. If you have to balance the harms here, you know, I can joke around and minimize it, but the company's suffering some harm, but clearly the harm on the other side here is these folks stand to lose everything. So if you're going to do it, you might feel sympathetic.
But balancing the harms in that situation is essentially rewriting that contract.
Agreed. Right. It's not. I'm actually agreeing with you that I am sympathetic to these people. But that's not the law here, and frankly, that really wouldn't even be justice here, right? I mean, we can argue and say law and justice aren't always the same, but geez, what have you done in order to try and comply with the terms of the contract? On virtually every area, you've done something wrong,
Yes.
right? I mean,
They argue that they had to do this or they would default on the promissory note. And
That's their argument. That's my problem with this. How does a judge or a jury or whatever this, who is the fact finder and...
you'd be the judge.
Okay, how does he determine the financial hardship of that plaintiff or defendant or whatever, an injunction, it would be the movement. How does he determine that? You know, he's not going to get in there and say, I want to see your financials. He might say, I want to see your financials, but you know, how does he know if the father that loaned him the money has money somewhere else? I don't know, you know? It's
by
not
the
up
way,
to him to think about.
The other thing, and this was, I just see it highlighted here, they didn't provide the insurance certificates to the franchisor. And that, if I was a franchisor, that would be a real big deal with someone running a bad shop, because that means that if you're not carrying insurance, I'm going to get hit financially here when someone does get sick, because you do have health violations somewhere here. So that's not insignificant, and I'm not sure any of them are insignificant. If I'm trying to make sure you have a good experience, you know, when you go to Applebee's, then all the Applebee's have to be up to par. Or when you go to Chili's, you sort of expect the same experience, whether it's Chili's here or Chili's wherever you go. And if we go into one and get food poisoning, we may not be going back. So if it's, as Pat suggests, the immediate irreparable injury might tip their favor, because, I mean, it paints a really sympathetic picture here, right? We're going to lose, not only are we going to lose everything, which that seems fair, because you messed up, but grandpa's out too. That's tough.
If that's accurate.
And listen, I think it should be. You all good with that? It's like you go home tonight and had a good day today, hon. What'd you do? Took away a cookie franchise and destroyed 3 generations of the family.
They made horrible cookies.
No, right? I mean, this is bad. But listen, we don't make these decisions, right? I mean, these were bad decisions they made, and they've got to live with those consequences.
Sooner or later, the free market would take care of them anyways. If they kept running a bad place, they're going to lose customers to the point where they're not making any money anyways. So they're going to lose all that money anyways. So if the courts never got involved, they would probably lose all that investment.
If anything, they probably go in deeper. I have to
Yeah.
say honestly, though, that when I started reading it, I thought, oh, is this the matter just about the batter? Oh, this is nothing.
Yep.
But then when you read various violations that they had, it's like, okay, wait a minute, you knew better. And even most of us, we don't get a second chance. So to get a second or a third or a 7-year chance, that's awesome. But I think that it's good that they stop now, because if someone's running like this, like Gary was saying, eventually in the future, they'll end up worse off than they are now.
Well, and I think that that's probably a possibility here. And I think from the cookie company standpoint, the franchisor, they're worried that this could reflect very badly on what we're trying to do. Listen, we don't always have to like the results of the work we're employed to do, but it's not our fault if someone habitually makes bad decisions. They've got to live with them at some point. I still think, I can see that old man crying in court more than a few times in my dreams, right? I mean, you are, aren't you? Just to be realistic, but he should be looking at his daughter and son-in-law. He shouldn't be looking at me.
I mean, they know the risk. I mean, you're making a substantial investment. You know the risk, you know the terms, and if you're not abiding by them and they've been given ample opportunity, you can't feel too bad.
But, okay, I hear that. You can't feel too bad. I'm asking you, though, aren't you gonna? You're gonna see a 75-year-old man crying.
For a minute.
His teeth, for a minute. For a minute. Okay, for a minute. Not gonna hold on to it. It's not my doing. If it wouldn't be me doing this, it'd be another lawyer. I mean, because
Right.
even in the civil context, there's some carnage left after us. But this isn't my doing. This is the result of a bunch of bad decisions by people close to him. I'm not close to him. He's not my responsibility. I'm not trying to sound overly callous, but I mean, sometimes these things turn out real bad, and this is going to be bad.
Bad for a moment. For the
Yeah,
guy.
I mean, it's no different than a bad investment in the stock market. I mean, I got hammered. Nobody was crying for me. So it's really the same thing. There's no
It's actually
guarantees.
worse because,
There
they
you
make
go.
all this investment, instead of taking it by the reins, they hire somebody and they say, okay, go at it. And if you're gonna put that kind of money and put that kind of stock into something like that, you better get behind it 100%. Otherwise, case in point.
The old man could have followed up on his investment by watching his kids too, or then, as a lawyer, you probably do a lot of rationalizations when you get into these
I
situations.
think that's probably true, right?
Right.
So he probably would say something to the effect, well, there's this poor couple over here that's dying to start a business, and if I get rid of these losers, I can get somebody that's worthy in here to run a business and be successful or something.
If Dad came in to ask your advice when this is all going down, what would be your? I mean, again, this is not really just legal advice, is it? Because I'd probably say, are you out of your mind? This is what you have for the next 15 years, and you're going to tie it up with them? Because I've had people come, this or that person, they need a cosigner on the loan. Why do you think they need a cosigner? So you understand that if it goes south, they're coming after you, right? And oftentimes they don't come in to have that conversation until afterwards when already there's the problem. But I mean, that's legal advice, not personal advice, is it? Listen, I know it's your son-in-law and daughter, but you need to understand, franchise relationships can at times prove very perilous. And I don't know what the number is. We ought to check that. And for some, significant percentage, they'll lose everything.
75% for all business in general. So
Fail.
within 5 years. So that's a proven fact.
Well, but then, you know what? Then I wonder then if the franchise is 75% of all, but only 60
No,
of
franchise
franchises.
is probably higher. Well, I would think franchise. I never know.
We're just guessing.
Yeah, because franchise.
We ought to look at it. We ought to know. I don't know whether you should probably look it up so you have some understanding. But I wonder whether that's part of your advice. I mean, I think it should be, because frankly, if you don't tell them this, that this is clearly one thing we know. It's all at risk. You could lose everything. Can you afford to lose everything if it goes bad? Well, they're giving me half the stock in the company. Yeah, but if the company goes out, they're bankrupt, you've got nothing, that stock's worth nothing.
It's a gamble.
Is that conversation done with the three of them present, or a son and daughter-in-law out while I'm talking to Grandpa?
Wouldn't it be the person you're representing?
So I'm representing son and daughter-in-law forming the corporation. I can just sort of ignore Grandpa. So where's the other $200,000 coming from? Grandpa's 401k. Does he work? No, he lives off that. Oh. Well, what? Where are you going, Sam? Yeah. So, but I thought I was just hearing that Grandpa's not my client, so I really don't care much about him.
It's true, but that's you got your client.
I would try to get him in there somehow,
I would suggest that he get himself an attorney.
So what do I do in front of the three of us? So listen, you really need your own lawyer because your money's all at risk. It is, forget it. And then now I got my clients I'm at. All I want you to start to think about is, we can sit in an ethics class and talk about what the requirements are and who our client is. But what we've got now is three people who are, to some extent, committed to try and make a deal work. And all we do from our training and reading these cases like this is we see red lights flashing and say, uh-oh, I remember we had that conversation in remedies. Because I guess I'd feel even worse. I would definitely feel worse if I were considered those three's lawyers at the outset, if I hadn't had some serious discussion with Grandpa, then I would feel being Great American's
You would talk to
lawyer.
your grandfather in front of the other two.
Well,
If you're their lawyer for all three,
Well,
then
but-
obviously.
If you're
But I
lawyer for all
can't,
three
can
of
I
them.
be lawyer for all three? I mean, this is what we're talking about, is that
There's a
there
conflict.
clearly is a conflict, right? And so it's you two are gonna run the business. Grandpa's really not having any of the business, but he's putting everything he's got up.
yeah. So you say to your client, you say, listen, you want to keep a good relationship with your grandfather, don't you? Then you need to have this conversation with
We
your
need
grandfather.
his
You're
money.
advising your
We
client.
need his money. I gotta be honest with you, Gary, we need his money or we can't make this
You need
work.
his money more than you need this relationship, because if this goes south, you've lost a grandfather. You've got to have this conversation. That's what you advise your client, to
Are
try
you-
to do that, right?
I don't know.
Yeah.
Are you willing to take your grandfather in and be his financial support? Because if he loses everything, how's he going to support them?
Yeah, sure. I'm gonna say that now, right?
Yeah, right.
So, okay, but where the rubber hits the road, these are not as easy decisions as they seem when we sit around the table. Because I've got the three of them in the room, and I gotta do something. And I don't want to make sure, if I'm not his lawyer, I need to make sure he understands that, because frankly, I'm probably gonna follow it up with a letter. Because I don't know whether he hears that well, and I know, I know people don't remember well when the spit hits the fan, the way it went down. And so there's going to be a letter at the minimum. And by the way, when I say he doesn't hear that well, not just because he's old. People hear what they want to hear. And that's something you guys need to understand is oftentimes they're only going to give you enough information so that they can hear what they want to hear. But even if you say something, they don't necessarily hear what you say. They hear what they've been listening for. And that's a problem too. So, well, they'll take out of this half-hour series of concerns that, well, this could work. And that's not the message. At any rate, let's finish our case. So the order was vague and deficient. And we actually had sort of dueling PIs, as you saw here, because the cookie company appealed not only from the grant of the Siegel's motion for a PI, but also from the denial of its motion for a PI against the Siegels violating its trademarks. And I think this is important for you to recognize as well. Oftentimes, when we talk about injunctions, we talk about the plaintiff's complaint and the plaintiff seeking an injunction. And if the defendant has a counterclaim, has a legal injury such that they can assert the counterclaim, then they can seek injunctive relief as well. So there will be occasions where it's not exclusively the plaintiff seeking an injunctive relief. Sometimes the plaintiff may file a claim for money damages. The defendant, by way of counterclaim, will assert its claims, and it'll only be the defendant asserting a counterclaim with a request for injunctive relief. You must have a complaint or counterclaim to seek injunctive relief because it's a remedy for a legal injury. And absent your complaint or counterclaim, you haven't alleged a legal injury. At the end of the day here, the cookie company gets its injunctive relief, and the Siegels do not. Their argument about we have no choice, we'll never be able to pay this, we've got to be given a little bit of latitude here. What's the big deal anyway? The court really doesn't cotton to that argument much at all. Because the court says here, the idea that favoring one side or the other in a class of contract disputes can redistribute wealth is one of the most persistent illusions of judicial power. It comes from failing to consider the full consequences of legal decisions. I think the PI initially was granted simply because the court felt, and I do feel bad for the Seegers. I don't think I feel bad enough to say that the 5 parties tip in their favor, though, even with such horrible consequences.
I'm more offended that the name is tarnished, the Great American Chocolate. You know?
The Great American Cookie Company. It seems, though, a little silly to be talking about runny cookies,
Runny brownies.
runny brownies, gum under the counter. Nasty? What? What's nasty? A runny brown?
The gum under the counter, that's nasty.
Go check that desk where you
I'm
sit.
sure. I'm sure. Grown people.
Grown college graduates.
Because they don't have to clean it up.
I guess it's better than putting it on the rug and stepping on it so they force it into the rug.
The people that take the class online don't have to worry about it.
No, they can stick their gum on their computer screen at home.
On the bedpost.
At the end of the day, there's a few things we're going to finish up. It's got to be a separate order. It's got to be clear as to what is ordered. And while our sympathies can go one way or the other in this case, and I also think it's important to think about this in counseling clients. They didn't jump in when the first mistake was made. There were a series of mistakes. There were a series of violations. So it's not, well, we just saw runny cookies. Almost, I don't know about every area, but there's so many significant areas that they're deficient in. To me, the insurance is the worst. But you also shorted me on the count by 40 grand, we know. We also know you were using supplies that weren't company authorized and didn't come from us. Geez, that's the whole nature of this relationship, is that to some extent, we're partners, even though we'll make money off each other. This relationship is broken and irretrievably, and as I do feel bad for Grandpa, but that's.
Now, can I ask you a
Yep.
question though? I like that you want to scare us straight. And then I know that there's probably going to be nightmares when we put our head on our pillow. So I wanted to ask you, have you had that, and what is your biggest, woe?
Well, okay, have I had what? Nightmares on the pillow? Of course.
Well, with your biest woe with your legal career before you even started teaching, what is it that you learned as being an attorney that you would impart?
I'm going to tell you by way of a story. I represented, for a number of years, I represented teachers in Boston, and for virtually anything that they could come in with. And I remember early on, one of the clients came in to me, and she was a good client over the years, but she came in, she said she found this house she wanted. It's a perfect house. The person she's buying from is a jerk, though. And so she doesn't want to mess this up. She just wants to say it's okay to sign this P&S. She gives me this P&S. And it's horrible, okay? Everything is slanted to the seller. And there's now she's a teacher, okay? There's no mortgage contingency clause in it. I said, do you have, I forget what the number was. I said, do you have that money? She said, no. I said, well, you're going to get a mortgage, right? She says, yeah. She said, but he says he won't, I can't have a mortgage contingency clause or he's going to sell it to someone else. I said, no. He mustn't understand it. She said, no, he understands it. He's a real jerk. And so don't ask. I said, well, I got to try and fix a couple of these other things, if that's okay with you, because the dates, there's just things wrong with it that it's so heavily worded to the other side that they're just relatively standard changes that no one could complain about. So I pick up the phone. So she leaves. I pick up the phone and call, and I don't know where I started, but I didn't get far. I said, paragraph 6 here. I said there's no mortgage contingency clause here. She's got to get a mortgage So I wanted to put in that she's got 20 days even, 20 days to get a mortgage of X number of dollars. He said, nope, forget it. Slams the phone down, just like she said he would. And I said, oh my God, because she told me not to do this. And now I've done it. And he sounded dead serious that this deal is over. And I have done precisely what the client said, do not do, because, and of course, I knew better, even back then. So I'm sitting there thinking, scratching my head, saying, what the hell? Because I got to get this back on track. So I decided to fudge a little bit and said, I think you I called back. I think you misunderstood me. I said, I wasn't saying this. I said, what would you consider? So at the end of the day, she with my concerns expressed to her orally and in writing, she went forward with the deal with no mortgage contingency, with a lot of other provisions in there that were absolutely bad for her if things got worse. But it was her deal, and this is what they wanted. And so the thing is, what I learned over the years is, at the end of the day, you need to do what they want to do, okay? Because they're the clients, and they don't want to settle. I have another one, and again, you need to do what they want to do within the bounds, as long as they're not doing anything ethically, even if they want to kill themselves, the rest. I tried a case out in Norfolk Superior one afternoon. It was simply on, she's looking for tuition for Boston College for her daughter for the next 3 years, for whatever reason. Well, the agreement was silent with it. They had been divorced for years. She was a god-awful client. She had gone, honest to God, she had gone through 10 attorneys from her divorce to now when she finds her butt in my office. And I was the young lawyer in the firm, so I got her because none of the more experienced lawyers wanted to get near it because they knew she had reported 3 lawyers already to the BDO, and I was number 10. And I'm not kidding. And she had taken one case all the way to the SJC by herself, pro se, and won. So, yeah, whoa. Car wreck waiting to happen. So we go out there. He offers virtually everything she could possibly get if we try this case. Virtually everything. And it might say at the time it was 70 grand. I think he offered 65,000 bucks. For the 3 years tuition at Boston College, he's going to come up with no more than 5 grand. I said, I don't think I can get better than this if we try this case. Nope, I wanted to hear the judge. I said, I think this is really a mistake. I said, this is a lot of money. This is the best. This judge, I mean, this even any judge, but I didn't like this judge anyway. I said, even any judge is going to be hard pressed to do better than this. Nope, I want every dime. I said, really, I said, I think this is a mistake. It's not my call, right? I could have probably shoved that offer down her throat. But with the history I just told you about, that would have been my big mistake, okay? And so I didn't. We tried it. Only took a couple hours the rest of the day. And she was a god-awful, I mean seriously, a god-awful witness. The judge, during her testimony, she wouldn't answer anything directly. It was clear that this was all about spite, even after a decade of not being with this guy anymore. And despite the daughter really needing tuition for school, the judge, he gave us, and they never do, gave his decision immediately at the end of the trial, saying, Nothing.
That's what you get.
Wow. And
Running that mouth.
yeah, that's right. Oh, she was mean and nasty. You could see at some point midway to her testimony, he turns off completely, not even looking at her, and I'm thinking, Jesus, I told you.
Did she try to throw you under the bus?
No. In fairness to her, no. This sounds braggadocious, but she comes up. No, I appreciate what you did. Listen, I just want you to know, of all of my 10 previous attorneys, you did the best job. Thanks, and see you later. So, this is what I've learned. It is their case. You need to give them advice. You need to document that advice in writing at times. But at the end of the day, we are, in essence, their agents. They're not going to tell me how to try the case tactically, right? If I choose to call Ash first or second. But frankly, over the years, if they say, you got to call Ash, and I say, he is god-awful, I don't want to put him on there. And they say, I think he's got something important to say. Again, this is something I'm likely to document and say, I would not call him. However, I will defer to your wishes and call him. But I think it's a big mistake. And if at the end of the day, they still even want to call ask, even though that would be seen closer to a tactical decision within my purview, I'm going to call ash for you, because that's what you want me to do, against my wishes. And I've had that conversation with people. Why do you keep repaying me if you're not going to listen to my advice? That doesn't make any sense, but it's advice we provide. And so I think the thing is, that what I've learned, be honest with them. Disclose the information up front that you have to disclose. Have a heart-to-heart talk with these three at the outset. Now, maybe there's some overlap here between who's the client and who's not. God knows there is. But frankly, you don't want to hire me because of the advice I'm going to give you, three of you, about how the entanglements are here, then good luck and go on your way and find someone else, because there's a car wreck waiting to happen and I don't need to be in the car when it does, okay? And so I think honesty, to the extent that you can provide that information, be clear about what they should expect and what's likely to happen, and also at the same time recognizing that we can't predict what's going to happen. We can give you best estimates. And at the end of the day, I think be as forthright with everyone as you can, but you're still going to have clients of the sort I talked to you about, and be a little more probably cynical than, but I think that's your law school training too, is what I've learned over 30 years now is I just never, no one's ever telling me the whole story. And that sounds overly cynical, but that's the world. And it's not even that they're lying. They're telling you what they saw through their experiences, right? This is the way they understood it. If you ask me how I saw something, I'm going to tell you how I thought it was. I'm not intending to lie, but it's just the way in which I saw it, the way in which I took it in, and the way in which I articulate it back now. Does that mean that's exactly how it happened? Probably not, right? Because we're forgetful and we sort of block things out. But I think it's important, to the extent you can, to make sure that you manage expectations early, be clear about what you can and can't do. And even though there may be some, and I'm sure one of our ethics people would tell us, I would have a serious conversation with the three in the room. And if they don't want to hire me, I'm really good with that, because this is one of these that you can see this. I mean, seriously, I would have big problems with someone putting everything they have. You know, someone, 75-year-old person, putting their entire 401k into this, and him never having run a cookie company in his life. But I saw something on TLC and it really looks good. I went to the franchise show this weekend. I think I could do this. That's dangerous, and I think I would have that conversation. So, we could talk more about what I